published after a 3 years research in 2018. His testimony included the effect of singing songs like, in quotes, kill dash kiss the boer, or kill dash kiss the farmer, the impunct song. The history of using words that are harmful, promote hatred, and incite harm on the grounds of race, ethnicity, and language, the effect of speech which seeks to dehumanize and delegitimize groups on the grounds of their race, ethnicity, and language, the effect of the speech which creates a toxic climate that makes it easier to target racial, ethnic, and language groups with acts of physical violence. As concerning the motive or motives of the attacks, Mr. Rhodes testified that 56.9% of the victims believed that the main motive is robbery. 11.8% believe that the motive is racial hatred, and 9.8% believe they are being paid for by a third party, and 7.8% say they believe the motive is revenge. He does not agree with the conclusion of the Committee of Inquiry into Farm Attacks, which was issued on the 31st July 2003, that 89% of the farm attacks are motivated by the intention to steal. He contended that the problem is made worse by the political climate. He only considered that only 2% of the farm murders were politically or racially motivated. He further accepted that the 2% does not reflect the racial demographics of the assailant or victim. He accepted that it may well be that the percentage, which is the 2%, included a white person attacking a black person on the farm, and that nothing is said in this regard about the impunct song. Mr. Rhodes traced the history of the impunct song to only after 1990, when it was popularized by the ANC Youth League leader, Peter Mokaba. He contended that the popularity of the song, subsequent to being sung by Mr. Mokaba, saw an increase of farm murders in 1993. In support of this contention, he referred to what happened during the Truth and Reconciliation Commission, where a certain Mr. Ntutuko Chueni confessed to the murder of a farmer and how the song had strong political influence on him. He also testified that the issue of land was a ruse used by the EFF to justify the singing of the impunct song. He contended in this regard that, quote, there is no hunger for land, close quote, amongst black people, and that is why most people migrate to the urban areas in search of housing. This statement was not backed by any scientific evidence nor statistical analysis. He further accused Mr. Malema of being undemocratic in his leadership of the EFF, and when asked to substitute, his answer was, and I quote, because you can see, close quote. EFF challenged the role of Mr. Rhodes as an expert witness. They in particular contended that he could not be an independent and objective witness because of his relationship with AfriForum. In response to the challenge of the expert testimony of Mr. Rhodes, AfriForum's counsel contended that the court should not apply the standard of expert witnesses applied in the formal litigation processes because that is not what was envisaged by the legislature in the Equality Act. He contended that what was envisaged by the legislation was an informal approach to dealing with the issues of expert witnesses. In other words, the well-known approach to dealing with the issue of the standard of expert witness would not find application in matters of this nature, according to him. It is well established that the role of an expert witness is to assist the court and not to be partisan with the party that called him or her to testify. Thus, the value of the opinion expressed by an expert witness is largely influenced by the witness's neutrality. In Stock versus Stock, the court held that the evidence of an expert witness who is partisan is of little value. In general, the practice is that expert witness is called by a party that believes that that witness' opinion would advance his or her case. However, the court observed in Schneider nominee office versus AA and another as follows, and I quote, "But that does not absolve the expert from providing the court with an objective and unbiased opinion based on his or her expertise as possible. An expert is not a hired gun who dispenses his or her expertise for the purposes of a particular case. An expert does not assume the role of an advocate, nor gives evidence which goes beyond logic, which is dictated by scientific knowledge, which that expert claims to possess," close quote. The standard of an expert witness was set out in the case of PricewaterhouseCoopers Incorporated and others versus National Potato Cooperative Ltd. and others. AfriForum's counsel, as indicated earlier, contended that the established and well-known standard of determining the qualification of an expert witness does not apply in considering complaints under the Equality Act. This proposition is, in my view, unsustainable. If that were to be the case, the legislature would have expressly provided for that. It is clear even from the version of AfriForum that Mr. Roots is disqualified to be an expert witness in this matter. He is, as indicated earlier, an employee of AfriForum, responsible for some of its strategic projects. He is responsible for coordinating its campaigns on farmer tax, a matter that is fundamental in this case. Mr. Rhodes is, on his own evidence, an advocate and activist on issues related to socio-political affairs of the Afrikaner communities, a matter that is central also to the issues in dispute in this matter. He, in this respect, stated that he has a vested interest in the outcome of the case, an issue that finds application in the consideration of whether an expert witness is qualified to testify as such. It is also important to note that Mr. Roots was unable to answer the question of whether he regarded himself as a witness. His response to the question during cross-examination was telling. He stated the following in the answer to that question. I quote, "I think the answer is both yes and no, or it is neither," close quote. He more importantly indicated during cross-examination that he has a vested interest in the outcome of the matter, as already mentioned earlier in the judgment. In light of the above, I find that Mr. Rhodes does not meet the standard required of an expert witness in terms of his qualification, his neutrality, and independence. His evidence was also based mainly on hearsay evidence. Mr. Human's evidence. The second witness of AfriForum was Mr. Witness. He's a qualified pastor of the Dutch Reformed Church and holds a BA, a BD degrees, majoring in theology. He is also qualified as a specialist pastoral counselor with 37 years experience in the ministry. When asked about whether those he counseled said anything about the impugned song, he responded as follows, and I quote, "In the places that we have been, there was nobody who said they sang this song whilst they were busy with us or whatever, or they were busy with their attacks, close quote. His evidence was based on victims who were referred to him to counsel. This included those cases attended to by those supervised by him at the trauma unit of AfriForum. He testified on the basis that he would not disclose the identity of the victims of the attacks and the murder for security reasons. There is no case made out by AfriForum as to why, if indeed the security concern for the victim was genuine, other alternative methods could not have been used to ensure their security. And if I may pause here and just point out that in the judgment, I do refer to the Constitutional Court judgment in the Kolani matter, where in that case, one of the witnesses was testified in camera because this witness was concerned about her security. So that's an example of what could be done in such circumstances. Accordingly, his evidence, and I'm referring to the evidence of Mr. Human, stands to be rejected. The evidence of Mr. Krause. The other expert witness for AfriForum was Mr. Krause, an employee of the Institute of Race Relations, the Institute, and responsible as head of campaign for mainly press releases and communication on behalf of the Institute. The testimony of Mr. Krause focused mainly on the song, open quote, Bizani Fire Brigade. Translation, open quotes, Call the Fire Brigade, sung by Dr. Nglozi in Senegal on the day of the hearing of the case of the people who were charged with the murder of a young farmer, manager Braden Homer. He sought to support the proposition that the singing of the song was hate speech by linking it to the fires that took place in the Free State in October 2020. He relied on media reports which indicated that the cause of the fire was the service protest by community members far away from where the song was sung by Dr. Ndlozi. He considered that on the facts as presented, there was no link between the singing of the song and the burning of the farms. I may add that this evidence does not in any manner provide a context upon which it can be said that the song does not deserve protection of freedom of speech. In my view, the testimony of Mr. Krause is of no assistance to the court, neither did it advance in any manner the case of AfriForum. The evidence stands to be rejected both because it was presented by a person who did not qualify as an expert, and also because even if it was to be accepted, it was of no probative value. Accordingly, the complaint in relation to the second song stands to fail. Mr. Meller's evidence. The first lay witness to testify on behalf of AfriForum was Ms. Meller, a teacher and a survivor of a farm attack. Ms. Meller testified about her personal experience about the attack on the farm. She testified during cross-examination that the attack was a robbery, meaning that it was not motivated by the singing of the impugned song. It is thus my view that the evidence of Ms. Meller provided no basis upon which it could be said that the singing of the impugned song had anything to do with the attack on her family. In other words, her evidence does not show that the singing of the song incited the harm that she ultimately suffered, and or that she is a member of a group that was discriminated consequent the singing of the song. Mr. Prinslow's evidence. The second lay witness was Mr. Prinsloo, a veterinary surgeon and also a survivor of a farm attack. He was attacked on the 20th November 2008 whilst asleep by 3 young men who, after shooting him, dragged him out of the bed and demanded that he must direct them to where the money was. He could not say whether the motive was robbery, but wondered if that was the motive, why did they shoot first and ask for the money later? He failed to testify during cross-examination as to how he came to the conclusion that the three, open quote, young black boys, close quote, that attacked him were influenced by the Impank song. His answer to this question was, open quote, well, I do not know, close quote. He considered later during cross-examination that even though the men asked for money, they were influenced by the Impank song. It seems to me that Mr. Prinslo's conclusion is that because the three men are black, they must have been influenced by EFF singing the Impank song. It is important to note that the attack on Mr. Prinslo occurred in 2008, and that is about 5 years before the formation of the EFF. As indicated earlier in this judgment, EFF was formed in 2013. In the context of the question, I beg your pardon, in this context, the question is how he could, sorry, just bear with me. In this context, the question is how could the song sung long after his attack have triggered the attack? There's no evidence that at the time of the Impank song was sung, it incited harm, promoted and propagated hatred against any specified group in as far as the evidence of Mr. Prinslo is concerned. In light of the above, I find the evidence of Mr. Prinslo to be of no probative value and accordingly does not assist this court in determining the issue in dispute. The EFF testimony. The respondent called one expert witness, Professor Liz Garner, and one lay witness, Mr. Malema. Mr. Malema, the president of EFF and second respondent in the matter, testified how EFF as a political party was formed in 2013 with the main objective of advocating for the struggle for economic emancipation of the previously disadvantaged South Africans. He testified about 7 pillars of the EFF which are non-negotiable and are set out in the manifesto, which include A, expropriation of land without compensation, B, the nationalization of mines, the banks, and other strategic sectors in the economy, C, free and decolonized education, D, the creation of jobs in South Africa. The EFF, according to him, is a leftist-oriented party representing the working class and thus engage in a class struggle with the aim of overpowering the white monopoly capital. Mr. Malema did not dispute having chanted, quote, kill the Boer, kill the farmer, close quote, during the period when he was the president of the ANC Youth League. He, however, contended that in his current position as the president of the EFF, he only chanted, open quote, kiss the Boer, stroke, kiss the farmer, close quote. He testified further that he was taught not to take the songs in their literal meaning, but to understand them to be referring to the oppressive state system. He did not dispute that he had, during the chant, displayed the gesture of a gun in his hands. In relation to the words, open quote, Boers, close quote, as used in the Impank song or chant, he testified that they understood that to be directed at the system of oppression. He went further to give an example that when black police drove into the black townships with police van during the apartheid era, they used to run away and say, there comes, open quote, the Boers, close quote, even when there were no white people in those vans. Asked about the impugned song, he testified that he understood that to be referring to farmers who represent the face of the land dispossession. The song need not, according to him, be literally taken. The cross-examination of Mr. Malema focused on his political ideologies ranging from communism, revolutionaries, land ownership, and custodianship of the land, and why he described white people as visitors in South Africa. He was also questioned about his hate of white people and killing of farmers. He was also cross-examined on the use of the word, open quote, kiss the Boers, / kiss the farmer, close quote. He did not dispute during cross-examination having sung or chanted the impugned song as reflected in the video footage shown during the hearing. Mr. Malema contended, open quote, kiss the Boer, / kiss the farmer, close quote, is not a song but a chant, and thus the choice of words would always depend on the person leading the chant. The message intended to be conveyed by the chant is, according to him, very clear in that it says, and I quote, shoot to kill Nyamazane, shoot to kill the enemy forces who are standing in between us and our freedom. And the word kiss is deliberately chosen to offend the white racists who do not believe that a black person should be allowed to kiss a white person. He also explained that the word quote, Nyamazane, is an animal, an antelope, a name used for freedom fighters. In support of his contention that the chant should not be interpreted literally, he referred to the testimony of the former President Thabo Mbeki when he testified before the Truth and Reconciliation Commission about the impugned song. He testified that the song should not be interpreted literally, but in the context of struggle and African culture. President Mbeki testified that in the absence of an ANC policy to shoot farmers, the song can only be understood in the context of culture and struggle song. Professor Ghana's evidence. The only expert witness testified for EFF was Professor Ghana, based at the School of Language Faculty of Humanities, University of Johannesburg. She holds a BA Honours, MA, and a PhD in African language and literature. She testified that the impugned, open quote, song is not simply a decoration, close quote. It, open quote, still carries huge weight as a historical statement, and it shows how songs can move through time and cause inspiration through memory to a later generation, close quote. It is true, she contended, that a political idea can be enacted through a song. In other words, according to her, listeners can enact a political idea and deduce messages through a song. AfriForum's case. In support of its contention that it is entitled to the relief sought, AfriForum relied on the recent Constitutional Court decision of Xolani versus the South African Human Rights Commission and others, hereinafter referred to as Xolani, where the court set out the test to apply in determining whether a statement is prohibited under the Equality Act. They further based the case on the tests set out in that case, contended that the ordinary meaning of the phrase, open quote, incitement to cause harm, close quote, suggests that one should not look at the harm caused by the speech itself, but rather to the impact of the speech on a third parties, i.e., does the speech encourage, stimulate, or call for others to cause harm, close quote. In order to amount to, open quote, incitement, close quote, the statement, according to them, ought to amount to an instigation or active persuasion of others to cause harm. The problem with the impunct song, according to AfriForum, is that it is sung in a climate or environment where farmers are frequently tortured and murdered, and thus that is good reason to believe that the words chanted by Mr. Malema and EFF call on people to kill farmers and amount to promotion of hatred on the grounds of race, ethnicity, and constitute incitement to harm. The other points raised by AfriForum in support of their complaint are that A, the impunch song constitutes unfair discrimination in that they are racist propaganda which incites racial violence. B, the songs are also, sorry, it should be the song is also directly harmful in that it causes severe trauma by reminding victims of farm attacks what they went through, as demonstrated by the evidence of Mr. Human and Mr. Prinsloo. C, harm is also expressed as harm to society, democracy, and the nation-building project. D, song is inimical to reconciliation. And E, the singing of the song is harmful to both the targeted group and the broader South African society. Regulatory legal framework. The issues raised in this matter are governed by the Equality Act, whose aims are to comply with the specific obligations in Section 9, subsection 4 of the Constitution. Section 9, subsection 4 requires the enactment of national legislation to prevent or prohibit unfair discrimination based on non-exhaustive list of protected grounds in Section 9, subsection 3, not only by the state but also by private persons. The object of the legislation are set out in Section 2 of the Equality Act and includes, amongst others, giving effect to the letter and the spirit of the Constitution in relation to equal enjoyment of all rights and freedoms by every person, the promotion of equality, the value of non-racialism and non-sexism. The other objects which are relevant in the consideration of the issues in this matter are the following. Roman figure 1, the prevention of unfair discrimination and protection of human dignity as contemplated in Section 9 and 10 of the Constitution, and Roman figure 2, the prohibition of advocacy of hatred based on race, ethnicity, gender, or religion that constitute incitement to cause harm as contemplated in Section 16(2)(c) of the Constitution and Section 12 of the Equality Act. It is clear from the reading of Section 2 of the Equality Act that the purpose of the Act is to advance the constitutional values and reconcile members of the South African society following the devastating consequences of the apartheid system and to promote democracy. As indicated earlier, this matter concerns the provisions of Section 10, subsection 1, and Section 7, subsection A of the Equality Act. Section 7, subsection A of the Equality Act reads as follows. A, the dissemination of any propaganda or idea which propounds the racial superiority or inferiority of any person, including incitement to or participate in any form of racial violence. B, the engagement of any activity which is intended to promote or has the effect of promoting exclusively based on race. C, the exclusion of persons of a particular race group under any rule or practice that appears to be legitimate but which is actually aimed at maintaining exclusive control by a particular race group. D, the provisions or continued provision of inferior services to any race group compared to those of other race groups. E, the denial of access to opportunities, including access to services or contractual opportunities for rendering services for consideration or failing to take steps to personally accommodate the needs of such persons, close quote. Before the decision of the Constitutional Court in Kolani, the test to apply in determining whether a statement was hate speech was that set out in Section 10, subsection 1 of the Equality Act, which reads as follows, open quote, subject to the provisions of Section 12, no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention, subsection A, be hateful, subsection B, be harmful or to incite harm, subsection C, promote or propagate hatred, close quote. In Kolani, the Constitutional Court declared Section 10, subsection 1 of the Equality Act unconstitutional and invalid. It suspended the operation pending an enactment by Parliament. The court further held that pending the amendment by Parliament, Section 10, subsection 1 of the Act shall read as follows, and I quote, subject to the provisions of Section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm or to promote or propagate hatred, close quote. It is tried that the right to equality and dignity have to be balanced with freedom of expression as provided for in Section 16 of the Constitution. In this regard, the Constitutional Court in Kolani held that the Constitution does not seek to protect the right to equality and dignity only, but also free speech is equally protected. The broad principle underlying the concept of freedom of expression and its associated rights is tolerance of different views by the society. Difficult as it may be to uphold, the society has a duty in terms of this principle to allow and be tolerant of both popular and unpopular views of its members. The test to apply in determining whether speech is prohibited as required by Kolani is an objective one that requires an assessment of whether a reasonable reader, or in this instance, a reasonable listener's view, would regard the statement as harmful. In the South African National Editors Forum and others versus Economic Freedom Fighters and others, in brackets SANEF versus EFF, close bracket, the court stated that even if the prohibited utterances in question could qualify as hate speech on its terms, but fail to incite or reasonably construed as inciting harm, no liability could arise in respect of Section 10 of the Equality Act. The inquiry to be conducted in applying the objective test is what meaning a reasonable reader or reasonable listener of an ordinary intelligence would attribute to the statement in its context. In Hodge versus University of Cape Town, the court held that a statement with an aggressive tone of hostility and overtones of race or ethnicity does not necessarily fall within the prohibition of Section 10 of the Equality Act. It seems to me that in statements of such a nature, it may be tempting for the court to treat the same as hate speech. In SANEF versus EFF, the court cautioned against readily declaring unpopular, offensive, or even controversial statements as hate speech. Is the Malema ANC 2010 case binding on this court? In my view, for the reasons set below, the judgment in AfriForum and another versus Malema and others has no binding effect on this court. The judgment is not binding on this court for the simple reason that the test it applied in determining whether the impugned song was hate speech is one that was that has subsequently been declared unconstitutional by the Constitutional Court in Kolani. The test which the court applied in that case was that the singing of the impugned song was, open quote, hateful. As indicated earlier, the test of, open quote, hate, close quote, has been expunged from Section 10, subsection 1 of the Equality Act by the Constitutional Court. Analysis and evaluation. I have already somewhere in this judgment dealt with the complaint relating to the second impugned song led by Dr. Ndlozi. I proceed to evaluate the first impugned song led by Mr. Malema. It is not in dispute that the impugned song is a form of a speech. In my view, AfriForum has in its evidence and submission failed to show that EFF contravened the provisions of the Equality Act by singing the impugned song. In other words, they have failed to show that the lyrics of the impugned song are based on prohibited grounds set out in the Equality Act. They have also failed to show that the lyrics in this song could reasonably be construed to demonstrate a clear intention to harm or incite harm and propagate hatred. The approach adopted by AfriForum in its proposition that the song hate speech is premised on the literal interpretation of the lyrics of the two songs. It is important to note in this regard that its witnesses could not speak to the philosophy and the history of the song. Mr. Rhodes came to know about the song, in particular the Dubula, after 1990s when it was apparently translated by the media into English. As indicated earlier, EFF presented its case through one expert witness and one lay witness. The most important aspect of Mr. Malema's, the lay witness, testimony is that the song has a significant relationship to both the issues of land and economic empowerment of the previously disadvantaged members of the society. Before democracy, the song was directed at the apartheid regime and more particularly to the dispossession of the land of the majority of the members of the society by the colonial powers. Since the dawn of democracy, the song is directed, according to him, still at the issues of the land justice, in this respect, more highlighting the failures of the current government. He insisted that the lyrics of the impugned song, similar to the other freedom songs, should not be interpreted literally, but within the context of the struggle and the political message that it sought to agitate. I beg your pardon, that is sought to be agitated. He testified that the issue of land justice cuts across racial demographic to include white women who have been excluded from the economy or by the system to benefit mainly white males. He did not deny chanting, open quote, kiss the Boer, kiss the farmer, close quote. He also accepted that the chant was intended to agitate and mobilize the youth to be interested in the struggle for economic freedom. He insisted that the agitation is not does not deprive one sector of the society of the land, but rather that the land owned by the state for the benefit of citizenry in general. I find no reason to reject the evidence of Mr. Malema. Equally, there is no basis to reject the expert evidence of Professor Ghana, who, unlike Mr. Rhodes, set out in her opinion in clear terms why the impugned song has, open quote, political role in the public life of the state, particularly in African states, because of the long cultural metrics in history of politics, song, and performance of African society. She interpreted the song as, open quote, not literally agitating an attack, but as a tool to advance the interest of the land justice. Close quote. In emphasizing that songs such as the Impank song should not be interpreted literally, she referred to a number of songs sung by She referred to another song sung at the EFF at its election manifesto launch. The lyrics of the song went as follows, colon, open quote, Malema o tshela tupa, tupa o a e bona, tupa e etla, tupa o a e bona, close quote. The English translation is, open quote, Malema is wielding a stick. The stick, do you see the stick? The beating is coming. The beating, do you see? The beating is coming, close quote. The literal meaning of the song would be that Malema is holding a stick and is ready to assault. This was in reference to the former President Zuma and members of his administration. In its proper political interpretation, the song does not agitate an assault on former President Zuma and members of his administration, but rather as a song pointing to the failures and inadequacies of the ANC government. Another song used by Professor Ghana to illustrate the importance of interpreting political songs in their context is a song that used to be sung regularly by the former President Zuma, whose lyrics are as follows, quote, let umshini wam, close quote, bring my machine, in other words, bring my gun. The proper analysis of Professor Ghana's opinion is that the Impank song has to be located within the political context in which Mr. Malema is pushing for land reform and radical economic policy. In explaining the value of songs like the Impank songs, Professor Ghana stated, quote, there was a sense of song uniting a gathering and being part of a moment of political defiance. The song was making a statement about the inadequacies of President Jacob Zuma and his ANC government. It's the beating, promise